Morning, my name is Claire Harrison. I'm the Managing Director of Harrison's, a Brisbane-based HR consulting firm that was established in 2009. Today's webinar is about conducting workplace investigations, and it will go for about 40 minutes. We are going to have some question time at the end, so we have included the Q&A function on for this webinar, which should be up the top of your screen, hopefully, or also the chat button is enabled. So hopefully we'll have time at the end to answer any questions. So if you want to send those through, and we'll collate them as we go. Okay, so a disclaimer, basically, Harrison's is not a legal firm. We're not giving any specific advice for your organisation. If you want that, feel free to come to us, but we are not lawyers. That is our disclaimer. In terms of Harrison, so like I said earlier, we were established in 2009 and we have 4 key service areas. So the first one being consulting, which can be anything related to HR, work health and safety, employee relations. That could include workplace investigations, it could include organisational restructures, training and development, employee relations advice, contracts, policies, anything across HR, employee relations and work health and safety. HR team is our service that specifically helps organisations that are more in that small to medium-sized organisations, anything from really about 30 employees to about 300, where they're experiencing the need for professional HR support to support their people and culture, but they've decided to outsource rather than hire their own professional HR manager. And so that service includes, we start off with a full HR health check, an employee engagement survey, we develop a one-page HR plan, and then we roll that out, making sure we're meeting both compliance needs, operational needs for the organisation. Our third service is recruitment and onboarding of employees, mostly around professional and managerial roles. And finally, our fourth service is My HR Experts, which is its own website, is a subscription service for organisations where you get a whole lot of content for you to manage HR yourselves, but there's also the option of tailored customised services and support from us and calling us when you need to. So that's a little bit about Harrison's. But importantly, let's look at today's topic. So today we're talking workplace investigations, and it's a hot topic. We've got a lot of people registered for this webinar. So I don't know if that's a good thing or a bad thing, lots of misconduct happening. But what we're going to talk about is when to act. So when is it that you need to do a workplace investigation? Because sometimes it's definitely not necessary. So we will talk a little bit about that. We'll talk about the role of the workplace investigator. Most of the session will talk about the actual conducting of the workplace investigation and the process and the plan that we use. Pitfalls I'll talk through throughout the webinar, but happy to take questions on that. And really it's about equipping yourself as the HR manager or the HR person or a manager within an organisation to be able to manage workplace investigations. So, and there's 2 real parts to getting a workplace investigation right when we're considering it. One is there's compliance and there's law that exists around it. But secondly, is also the culture that exists, because I'm sure you've all experienced, we get complaints whether related to bullying, harassment, discrimination, fraud, theft, whatever they might be. And you know, it's about that issue and that allegation that we're investigating, but it has a huge impact on the culture of the organisation. One is in terms of what's actually the problem, the misconduct, but also impact on the culture and the morale and everyone else that's involved in that investigation and the broader ramifications of what's going on. So we need to, when we're managing workplace investigations within an organisation, we need to make sure we're meeting our legal and compliance needs, but also really thinking about the support and the culture of trust that we're trying to build within our organisations. Okay, so let's talk about when to act. So you receive a complaint and maybe someone asks for it to be investigated. That's not necessarily the right course of action. So there's a number of aspects to consider when we're looking at this. So there's investigations within a whole range of organisations. You'll get them from customers, from clients, and we have obligations to a whole lot of people, patients, parents, carers, depending on what environment you're in. But this session is really about the employee and the workplace situation. So I think just there's a lot of points here, but I think before we start investigating, there's a number of things to consider. So the first point I just want to make really clear is, so there's an allegation, someone's made a complaint, or there's a concern that's been raised. If it was substantiated, if it was proven to be true, would that actually breach any law of company policy? What would it breach? Because I say that because if it's not misconduct, so therefore it's not a breach of legislation or company policy or something similar to that, then potentially a workplace investigation is not the right course of action. So I think a common one that we get when we look at investigation is when there's two people within a workplace and one or both of them are alleging workplace bullying or harassment against each other, or just one of them. And so sometimes the first thing to do is to sit down and really talk to the person that's brought the complaint forward to you, or the concern, whether it's the manager or the people involved, and ask a lot of questions to establish what is the issue here. And in many cases, when we have these come through, is often it's more of a personality conflict, a style of work that's the issue, rather than workplace bullying. So it's important to establish that from the beginning, because if it is more of a conflict of styles, or it's a procedure, or it's a lack of training, then a workplace investigation is not the right way to go. It may be mediation, it might be training, it might be redoing a position description, it might be redoing a procedure. So I think just a word of caution, just because we get a complaint through and people are saying it's bullying or sexual harassment, we definitely need to take that seriously, but you first of all need to ask some questions in terms of, okay, so if what this person was saying was true and is proven, would that be bullying by the definition of bullying? So a really important point to consider before you go down that track. So there's some other points here. I think the performance issue is one as well. So, poor performance doesn't normally warrant a workplace investigation. It doesn't mean to say that if you're going to start down a disciplinary path with someone, is that you shouldn't gather all the evidence related to their poor performance, but that's separate from a workplace investigation. Workplace investigations are really around misconduct. So there's some other points here, but I think really they're the points that I wanted to raise before we go fully fledged into talking about workplace investigations. So just when we're thinking about the legal considerations or what's been breached, there'll be policies in your organisation. Hopefully, there may be codes of conduct, but importantly also, if you have a policy that talks about, and it normally would sit within your bullying policy or discrimination policies, that talks about how workplace investigations are conducted, you need to ensure you are complying with your own policies. So just think about, though, these are policies or procedures that your organisation should have in place that potentially the employee is breaching. Therefore, there might be that basis for misconduct that we need to investigate. But thinking about your procedures and how you need to comply with those. In terms of legislation, so when you're conducting an investigation, there's a whole raft of legislation that exists, but you need to think about the definitions of, for example, workplace bullying, sexual harassment, discrimination that sit within legislation, because that's what you're investigating against. So examples of misconduct allegations could include any of these. I'm sure you've all come across them, but these are just some examples. Okay, so you're going to see this slide a few times throughout the webinar. So this is really about when you have an investigation, it's really, really important to sit down and plan the entire investigation out. So that starts with, and we'll talk to each of these points, but appointing an investigator, then looking at the complaint, looking at the allegations and drafting the allegations, determining who the appropriate witnesses are, notifying the respondent of the complaint and the investigation commencing. And like we just said before, considering the relevant laws or policies that apply to the investigation. So that's about scoping the investigation. Then we move on to the gathering the evidence, so preparing your questions, talking to the respondent, talking to witnesses, and then gathering any other evidence that you may need. And then finally, is the findings in the report. So considering all the evidence, the law, the policies, whatever else that might be, what are your findings against that? It's completely based on facts, and then it normally all is summarised into a report that gets submitted to your decision maker, for the decision maker to make the call in terms of what happens next. So that is the overall process that we use for a workplace investigation. So I will come back to that throughout the webinar. Okay, so first of all, we have to appoint an investigator. So I'm going to talk about the role of the investigator. So they need to be independent to the parties involved. They cannot be involved in any of the complaints that have been brought forward. The role is purely about establishing facts, not to determine if someone is guilty or innocent, nor do they decide on what happens next in terms of disciplinary action or anything else. They need to act promptly. They need to communicate with professionalism, with seriousness, about the matter and clearly to everyone that's involved. They need to remain calm, and they need to be impartial at all times. Just remembering it's really about fact finding and making decisions and findings based on the evidence, not anything else. So that's the role of the investigator. In terms of who should conduct the investigation, so most importantly, they need the appropriate skills and knowledge and experience to be able to deal with the situation. When conducting internal investigations, which a lot of HR people do, the investigator must be of at least equal or higher status. And ideally, the investigator should not be the decision maker for disciplinary action. I'd say not ideally, that should definitely be the case. So, we get the questions about what should stay inside versus going outside. So in terms of appointing an external investigator. So if you have trained, qualified, experienced people that are independent of the complaint within the organisation, then the investigation can be carried out within the organisation. There's no law, other than you may have a policy, that says that you have to outsource or, get an independent external investigator. Where we often get involved in workplace investigations and conduct them is for the more trickier, complex workplace investigations, and or those that involve senior positions within the organisation. And it is it's a legal consideration for an organisation to consider. There's often public PR, public relations issues that need to be considered. And you do need to get it right because, unfortunately, I have had to testify in federal court for an adverse action claim about an investigation that I conducted. So you need to really ensure, the higher the risk, the more important it is to ensure that you've got the right skilled and experienced people conducting your investigations. So the prime objective of a workplace investigation is to determine, did the alleged wrongdoing take place? Has the respondent breached a company standard, policy or procedure or legislation? And coming out of that, what is the necessary action? Often with a workplace investigation, we're talking about disciplinary action, but it may end up being something else. It's really about establishing the facts. It's the key requirement, mission of the workplace investigator. What are the facts? And then ultimately looking at the allegations and what has been breached in terms of legislation to determine, we will say, is it substantiated or not substantiated? We'll talk a bit more about that at the end. So your investigation must do the following. When we're talking about what your investigator is doing, you want to be moving as quickly but efficiently as possible. And I say that because for the reasons I said earlier about protecting your culture as well, is one is that everyone that's involved in investigation, it often involves a lot of stress and anxiety. So you want to keep moving through that as quickly as possible. It impacts on morale, productivity of the organisation, and importantly, more from a legal perspective, if we're saying the issue is so significant that it warrants a workplace investigation and potentially standing someone down, which we'll talk about later, then we need to move quickly. It's not something that can be delayed. So move through that process as quickly as possible, but efficiently. Use more than one person's version of events to determine what occurred as much as possible. Sometimes that's not possible. Collate all the information relevant to the allegations. So normally that involves interviews, but also a lot of evidence gathering around emails, documentation, photos, whatever else that might be. And it's really considering all that evidence to draw conclusions objectively and impartially. There's a written report. We're complying with law and policies. It's facts-based. And there's a written report of the process that gets submitted to the decision maker. Come back to that side note at the end with the report. Okay, so key takeaway in terms of looking at the investigation and the investigator is during the investigation, have to maintain procedural fairness at all times and how you treat everyone involved. So that includes the person making the complaint, the person who has allegedly done the wrong thing, and any witnesses that are involved in the investigations. Everyone needs to be supported. Employee assistance program needs to be offered. Everyone needs to be treated with respect and fairness throughout the investigation. There needs to be a consistent and fair investigation process, which we plan out in advance. We need to build trust throughout the process. It needs to be very confidential, and we want everyone involved who needs to be involved, but maintaining that confidentiality throughout. We want to also affirm the company's values, their expectations around behaviour in terms of fairness in the decision making, and listening to everyone who is involved in the allegations, listening to what they say and considering what they say. Again, that's bringing it back to the culture, because once this investigation is finished, life needs to go on, business needs to go on, and we really want to be protecting that culture and building a culture of trust with our people. Okay, so in terms of conducting the investigation, let's talk about the actual doing of the investigation. So back to our planning. So we're going to talk about each of these steps in terms of the scope and the gathering evidence. And so this is really the main part of the presentation, is about the conducting of the investigation. So just to talk about the terminology and what gets used. So complainant, the person who's made a complaint. I'm going to make a quick note here just in case I don't do it later on, is in regards to complaints and the role of you as a manager or a HR person within an organisation. If you have someone that comes and talks to you about, a serious issue such as sexual harassment, workplace bullying, but they say that they want to keep it secret and confidential and don't want you to say anything, you need to be really, really, really careful about that, because as an organisation, a business, and the person employed by that organisation, it is your responsibility as both an employee, a manager, a HR professional, to actually do something about a risk within an organisation once it's been identified. So you need to be really clear with people, is that you'll try to keep their name confidential, but you need to do something about it. So that level of confidentiality cannot be completely guaranteed. So just that point. The respondent, so the person who allegedly has done something wrong. Witnesses, so someone who may have observed an interaction. So, and just a point on witnesses, we're looking for someone that has first-hand observation or information. We don't want to, we're not going to look at hearsay. Is not a good form of evidence in terms of gossip or someone said something or whatever else. We're looking for first-hand evidence. An allegation is a claim or an assertion that someone has done something illegal or wrong. So we talk about allegations. The Fair Work Commission, you're probably aware of. Support, just a note on this. So I think it's really important when we do have an obligation as an employer to support people in the workplace, but definitely throughout workplace investigations. So we want to make sure there's regular check-ins with the people involved, especially the complainants. The respondent will be in a very sensitive situation, and others that are involved in the investigation. So thinking about how we are going to check in, how we're going to provide support. Definitely an employee assistance program is a great form of support. It's difficult for a manager and people that are involved in the investigation understand in terms of, they get questions about what's happening. There is a responsibility for all employees within the organisation that they owe to their employer around confidentiality, as well as victimisation. So it's about managers being able to reinforce some of those messages in terms of it's happening in a procedurally fair way, it's free from judgment, but we can't go out and broadcast that to everyone in the organisation that there's an investigation going on. We want to limit it to as few people as possible. And just thinking to my point earlier is, thinking about how any delays can be minimised once we start the investigation and once the complaint is made, until the point that we actually get to where we can provide the respondent with the allegations. So just trying to move that process along as quickly as possible, but also as thoroughly and effectively as possible. So just some key takeaways there. Ensure the investigation process is not procedurally flawed. There's some very clear, robust procedures that need to happen through an investigation. There's a lot of paperwork involved, a lot of evidence gathering, a lot of documentation, a lot of communication, but it all does need to be documented. So we have that evidence of the investigation, but also the right evidence is being used to substantiate on our allegations. We need to test the evidence. So, that might mean going back and doing second interviews or looking for some other information. We need to give the parties a reasonable opportunity to participate and to consider the evidence that's against them when we're talking about the respondent. And we need to protect the rights of everyone involved in the investigation is really important, and making sure that we're offering support. Okay, so let's start with the complainant. So this can come through a verbal discussion, it can come through an email, it can come through someone said, this to me and I'm passing this on to you. But what we want to do is, a first point is we need to get details of what the complaint actually is. So often that involves, I would often ask them, if I've heard about it, can you put something in writing and send it to me? But even when that happens, I still sit down and go through and ask a whole lot of questions about the complaint. So if they're not going to do that, then you still need to speak to them and you need to make your notes. And we need to go through in detail what is the complaint, what are they alleging. We want as much detail as possible. And, it ensures the investigation is really targeted to the information at hand and not the unimportant information. And I say also too that the complainant or complainants might raise a whole load of issues. And back to the point earlier in terms of determining the workplace investigation, there will be some things that they complain about that more likely won't be the subject of the investigation because they're not, if they were proven, they wouldn't be workplace bullying or sexual harassment or a breach. There wouldn't be misconduct. So you need to, work your way through that as well. But really it's starting with understanding what the complaints are and a very open conversation about what that is. That'll help you scope the investigation. So that is the starting point. So the complainant statement, like everyone, we seek permission to record the conversation. If you're doing it via Teams, then I give notice that we're going to be doing that, or you do that at the meeting, or if you're recording via your phone, you let them know. Explain your role as the investigator in the interview and your impartiality, important to stress that. And, really even from the complainant is, you're not here to make judgment on what's being said. Your role is to investigate, seek facts, and you won't be the decision maker in terms of where this goes next. So ask the complainant for that information that I've got listed there. And importantly to ask, so what other evidence can support the allegations in terms of who was there? Were there any emails? Are there any documents? Is there video evidence? Is there anything else that might help to substantiate or not those allegations? So, and just, when you're asking and interviewing the complainant is just to continue to ask prompting and open-ended questions. Importantly, and we talk more about interview questions a little bit later, but we do not at all throughout any investigation want to be putting words into people's mouths. So we're asking very, very open questions and hearing it from them and taking notes of that. So really important to get the open-ended and not putting in people's mouths. We can ask a clarification question requiring a yes or no, but that is not something like, okay, so is that workplace bullying? We're not asking that question. We're only asking clarifying questions. So you mean that happened after work, which was 6:30 on a Friday. Yes. So just be careful, very open, not leading questions. Okay, so once we've got the complainant statements, then what we can do is start to form the allegations. Allegations need to be written in a very careful way. They need to be as specific as possible, and they may change throughout the investigation. So often what happens is, I would meet with the complainant, you meet with the representative from the organisation. I'm talking about an external investigation, and I will draft allegations at that point and put them back to the organisation to help scope the investigation in terms of what I'm doing the investigation against. But what often happens is once you meet with some of the witnesses, there's other information that comes out and potentially more allegations or a rescoping of the allegations is required before they're put to the respondent. We're not going on a witch hunt, I'm not saying that, but if there's other evidence that comes out, it will reform the allegations. So to talk about allegations, so well-drafted allegations, they really need to be as precise as possible, but not too precise. So when did it happen? What happened? And remember, it's all facts, okay? It's not facts. We're not putting words into people. Sorry, it is facts. We're not putting words into people's mouths, and we're not making our own opinion or judgment about what's being said. It's facts. So who was involved and where did it, as much information as possible. So keep it objective and free from emotion is important, and have something to hang your hat on. So recommend that allegations refer back to the relevant policy, contract term, legislation, the actions, if proven, they may be breached. So, if it's sexual harassment, we're going to talk about it breaching a sexual harassment policy and or potentially sexual harassment legislation within the allegation. Rumour does not have it. Like I said before, we cannot make allegations based on gossip and hearsay without talking to the person that was actually involved in the incident. Timeliness, so time, we need a time frame, but we need to keep it moving. Keep your evidence separate from your allegation. So the allegation is what gets put forward to a respondent. We're not giving them all the evidence. They're two very separate things. And when we're talking to interviewees, complainants, we're not giving them all of our evidence. They're two separate things. So as an example, an allegation. I was in the office a few weeks ago. I just finished getting a coffee in the kitchen when Joe Bloggs said something to me which made me angry. I think it was get lost or something like that. I really think he's trying to make me so uncomfortable that I quit my job. This is not the first time he has done this. A few years ago, he said something similar as well, and I've heard from others that he has done the same thing. So that's a complaint you've received. So, if we're workshopping this in workplace investigation training, we'd spend some time talking and chatting about this. But what we'll look at is, so this is a bit light too, so hopefully you can see this. So the vague and imprecise in the first column, but what we'd look at more is, so in and around June 2021. If we've got a date, I'd still be saying in or around the 5th of June 2021, so as not to get that wrong. What happened? Joe Bloggs said words to the effect of, get lost, we're in the office around the vicinity of the kitchen. So trying to get more specific, doesn't need to be, completely precise, but getting closer to something that's more specific. So in or around June 2021, in the office in the vicinity of the kitchen area, Joe Bloggs said to Jane Citizen, words to the effect of get lost. This conduct, if proven, may amount to a breach of the bullying and harassment clause of the company's code of conduct. So that's an example of an allegation. Key takeaway, you must establish the facts of the allegation before you begin collecting evidence. Really important, that complaint, these are the allegations, because those allegations are what you use to plan out every single interview. It's what you use for your evidence, and it's how you decide who you're going to interview. Because if someone came up in the complaint that is not an allegation that would lead to misconduct, then you're not talking to that person. If it's a hearsay person, then we'll probably avoid talking to that person as well. So really important to be really clear on what the allegations are. And so the investigator's task is to gather sufficient evidence to determine whether the breach of the company policy legislation has occurred and if it can be substantiated based on the facts. So remembering that all the time to keep the investigation very precise and tight. Okay, so let's talk about interviews. So you'll be conducting a lot of interviews in an investigation, so it's important to get your methodology right. I plan in advance the record of interview documents, so I have in there all of my intro, everything that I need to say, and then I have some specific questions that I'm going to ask, all open-ended questions. But really important to plan that out, to document it. I document, type, as well as recording them. So important to get that right. So interviewing, ideally you should interview all participants face-to-face. We do use Teams, so we can do that in person, but we don't want to be doing it via the phone, and we don't want to be doing it without cameras on. Much easier to build rapport, making them more likely to be forthcoming with the relevant information that you need, better able to fully engage with the participants, and you'll become more familiar with the participants' communication styles so that you're better able to interpret their verbal and non-verbal messages to judge their credibility. Because when we are writing up the report and making our final recommendations, the credibility of the witnesses and those involved is a consideration in that. So interview questions, I can see what time we're at, so I'm not going to go through these, but just remember then rather than closed questions, we're trying to keep it as open as possible. So interviewing your witnesses. So you've interviewed the complainant, then you've planned your what the allegations are, you've determined who the appropriate witnesses are, and then we start interviewing the witnesses. So importantly, what I do, if just in case I haven't mentioned here, we do a notice of interview, which goes to each of the witnesses in advance. So in communicating with witnesses, disclose as few details about the allegations as possible. They don't need the full detail. We need to keep it open. We don't need to be leading them in any way. We're looking for their information. You can avoid telling them who the complainant is and the respondent, if that's possible, or anything about the allegations, unless they need to know that information to be able to provide the evidence. Doing this will really help to protect confidentiality, avoid witness collusion before interviews, and obtain the best evidence. So really important considerations with witnesses. So again, interviewing witnesses, we want to hear it in their own words. Again, we want them, you'll need to bring them back in terms of the facts of the situation. So, what did he say? Where was he standing? Where was his hand? What did, if someone was there, where were they standing in terms of a witness? Did they say anything? All those questions. Look for specific details, time, location, who was involved, other witness. Ask open-ended questions as much as possible. Beware of the reluctant witness. With the reluctant witness, to me, it's about building rapport as much as possible, but continuing to ask those open-ended questions as much as possible to get the information you need. In terms of reluctant witnesses, people that say they don't want to be involved in an investigation, it is, if we want to go down that path, it is a reasonable direction of an employer for a person to be involved in an investigation. In part of their employment relationship that exists, but often, as I'm sure you've experienced, sometimes that becomes, not a valid issue anyway when you've got someone sitting there not wanting to say too much. It is not uncommon to have an unreliable witness. So if you chose not to interview a witness, you should really record your reasons for doing so. And there's a number of reasons for that, but we won't go into right now. Interviewing the respondent. So we've interviewed the complainant, we've got the allegations, we've done our interviews with witnesses, we've gathered some more evidence where we need to. Moving towards the pointy end is to interview the respondent. So I just wanted to add a point here about suspension, standing down. So most organisations within some sort of industrial instrument, whether it's an employment contract, an award, an industrial agreement, legislation, there's an option to stand down. And in many cases where there's a workplace investigation involved, it's a serious issue, especially if it impacts on safety of people, whether it's psychological safety or physical safety. It is appropriate to stand the respondent down. So that would go into, so the first thing we do right back at the beginning after we've spoken to complainant and we've decided to start the investigation, is we do a notice of investigation to the respondent to let them know there's been complaints of misconduct that have been made against them, that they've stood down on full pay, whatever that looks like. They're not to make contact, whatever that looks like. But also talk about they're not being prejudged, it's impartial. They will have an opportunity to respond. There will be an interview, remind them of obligations, as we do everyone involved in investigation, around victimisation and confidentiality. We support them like we support everyone else in the investigation in terms of offering employee assistance program and keeping the communication going. We're clear with them, I'm a workplace investigator, I'm not the decision maker, and we let them know who the decision maker will be in the process. Outline the possible consequences if the allegations are proven. So, for example, if these allegations are proven, it will be workplace bullying, which may lead to disciplinary action, possibly the termination of your employment. So they need to understand the severity of what's going on. And then we do the notice of interview once we've gone through the complainant, we've interviewed the interviewees, we've gathered evidence, we potentially have reformed our allegations. We do a notice of interview, ask them to come in to meet with us, or via Teams, or however that might look, and that includes the allegations for them to respond to. So this all happens before the actual physical interview. So in terms of the actual interview with the respondent, so you provide details of the allegations made against them in the notice of interview. Again, we're asking open-ended questions to get a response to each of the allegations. You can ask generally for a response, but then you may get down to asking more specific questions in regard to what happened. By this stage, you've got a lot of evidence about the allegations, so there'll be specific questions that you will need clarification on. Again, we're looking for open questions as much as possible. So often the first answer, and this goes for interviewee, this goes for the complainant and the witnesses as well, is often the first answer is not the only answer. So, continue to ask those, those open questions in terms of why did that happen? What happened then? Okay, then what happened? And who else was there? So continuing to ask those probing open questions to get that more information and the evidence and the facts that you need as the investigator. Prepare questions that you know the answer to check honesty of the respondent. Don't automatically dismiss any counterclaims. They may not be topical for the investigation, or they may be, so you need to make a decision as an investigator about that, but they may be a separate issue, which often happens in a workplace investigation, is that there's a lot of potentially deflection or blaming others, which can happen in disciplinary meetings as well. But you need to determine, what's relevant and what's not. Support the respondent just as you would support the complainant. And I just want to make a response in writing. So definitely the preference in my mind is to do the interview with the respondent face-to-face, whether it's a Teams or face-to-face, for the reasons that we said earlier about face-to-face conversations. And it just, it gives you a better feel of the person, the way they're responding, how they're saying it, for you to be able to make your findings. But in some situations, we will do a response in writing. So that's where you've issued the notice of interview with the allegations, and you'll provide them with the option, or that will be the only option in terms of giving a date for response to be provided in writing. And then again, there's a number of reasons for that to be considered. Okay, so we've gathered all the evidence, we've done our interviews, we're moving on to the findings and the report. So before, we've finalised the investigation, do you need to conduct any follow-up interviews if necessary? So it may be that the respondent raises some issues or said some things that you need to go back and check on. So you should do that. Keep the parties informed of the progress of the investigation, have all the terms of reference been addressed, and that's really about everything that was raised in those initial allegations. Has that been addressed? Is there any more fact-finding that you need? Have all relevant witnesses been interviewed, and have all the relevant pieces of evidence been collected? So just before we finalise and write the report, just reflecting back on that. So analysing the evidence. So the way we do it is an evidence matrix. So it looks at what are the potential breaches, what are the allegations, and then across the top we've got all of the pieces of evidence, which will be the complainant, the respondent, everyone interviewed, and other forms of evidence. And then that comes in to determine if we have sufficient evidence to substantiate or not that allegation. Findings should be based on fact. We've said that. It's either substantiated, it's not. It either did happen or it did not happen. And we need to be clear on why we came to that conclusion. So just on the consideration of findings, it's based on the balance of probabilities, which is different to beyond all reasonable doubt. So that's something, again, it's a legal consideration. There's some case law around that needs to be considered as well. But, you know, sometimes what does happen is that you can't substantiate an allegation, but that's only because you've got a situation of someone said one thing and someone said another, and there's no witnesses to that. Sometimes you can substantiate based on other evidence in terms of, you know, emails or previous situations, but sometimes it's not. When we unsubstantiate an allegation, it doesn't mean that it didn't happen. So analysing. And then finally, we have a workplace investigation report. This is the general sort of content that would include. So what was the original complaint, an overview of the process that we've used, the allegations, the evidence that's been gathered, and evidence including the response from the respondent, any other legal and considerations that I include there, anything, you know, if we're doing a workplace investigation, that I would include that definition, anything that comes out of a policy or that contract as well. And then overall the findings for each of the allegations, and I do overall findings as well in terms of what's been breached. And then recommendations, just remembering the purpose of the investigation is to substantiate or not the allegations. So often we don't include recommendation. That comes down to scoping in terms of what they're looking for from the investigator. So the report should be written in language that's suitable for the target audience, who's the report going to, and it will include background to the workplace, the environment, the people, the roles. And when I say other considerations too, you know, sometimes that does include what training and education has been provided. Other considerations, like if it's a sexual harassment complaint, is that potentially the person that's been accused is in a power position, maybe, as an example, an older male, and we're talking about all younger females. There's a power imbalance. There's also a gender issue. So that is relevant to considerations. It may be that there's previous warnings or that have been issued to the person on a similar sort of thing. So all of that goes into considerations. Also the consistency of evidence provided. So if we've got someone involved in the investigation that changes their story every time or says incorrect things, then that's also goes in that consideration section. So that is the report. We're getting close to the end. I see we've gone over time. Reminders on workplace investigations. A good investigator has the confidence, the knowledge and the skills to listen, interview and communicate effectively, manage the investigation so that all parties understand the process, keep parties informed and be available to answer questions, apply common sense and logic, process and rapidly respond to new information, adjusting the investigation as necessary. Often that's involving other people or reforming allegations before they get submitted to the respondent. You know, obtain legal advice where is necessary, because sometimes there is some really tricky situations in workplace investigations. Evaluating conflicting evidence and judge the credibility based on facts of individuals involved. Make judgments that might affect colleagues' professional and personal interests. That is difficult when you're an internal HR person or manager conducting an investigation, when you know it's going to impact on people that you're working with every day. Make findings on the balance of probabilities based on evidence. Understand the relevant policies, procedures and codes of your business and any special requirements of privacy, surveillance laws. Be independent, unbiased, impartial and non-judgmental. Natural justice, procedural fairness, empathetic to all involved. Follow the steps of your own policies and procedures. Treat everyone consistently and equally. Deal effectively with any criticism, challenges. You know, you can sometimes be the brunt of a lot of criticism and harshness as the investigator or the HR person involved, but being able to deal with those professionally is important. Manage participants who may attempt to derail the process. Okay, so what happens? The report goes to the decision maker, and then really it's up to the decision maker to make the call on what happens next. You've done your part as the investigator. They may come back to you and clarify some questions. You may need to make some small amendments, but the decision maker does not direct the investigation. It's you as the investigator who makes the findings. So what happens then is basically the decision maker decides on the appropriate form of action, which we've listed what they may include, and then there's an outcome of the investigation that people are generally informed of, that the investigation is concluded, but we don't need to tell everyone that was involved or others what the decision was in terms of next steps. So back to our planning. So scoping, gathering evidence and findings. I think we've covered all of that. So important to get a really good scope, talking about the allegations with the complainant, be really clear on what has actually, if that behaviour was proven, what would it breach? Gathering evidence, gathering facts before we make our findings to substantiate or not these allegations, and preparing a good report. So I have got here questions and tips and tricks. So I'm just going to check if we have any that have come through. A template for the evidence matrix. Yes, potentially we do. So if you want to email info@hhr.com.au, I can provide you with something. Can a witness refuse to participate? I think I covered that point earlier. We can direct them in the course of employment. It's a reasonable management directive, but I suppose then the consideration is how useful they will be in terms of providing evidence, and something to consider. Third question, what do you do if the respondent goes off sick before you get to meet with them? And I'm sure we've all experienced that. We won't put any allegations forward and do the interview until the person is cleared to be able to participate in the investigation. So they were the questions that came through. So thank you for those. In terms of what you need to think about is, I would say often the downfall of organisations is that they don't have the right processes, policies, training systems in place to protect the organisation from the behaviours that are happening, and that's to be able to protect themselves as an organisation from vicarious liability and their requirements to reduce risk for these types of behaviours. So my question is, do you need to train your HR and managers on conducting workplace investigations? We offer a more thorough workplace investigation training course if that's something that you think your organisation would benefit from. Do you need to think about outsourcing complex workplace investigations? Do you need to, if you don't have them already, develop HR policies, procedures and training, especially around bullying, sexual harassment, discrimination, and code of conduct, and not just having the policies and procedures in place, but how we're training people on them regularly. Importantly, and we see this often, unfortunately, is not in place, is to develop and communicate your complaints process. Do you have contact officers? Are they trained? There needs to be people that are trained and trusted that employees can go to if they have concerns. An employer needs to have that in place. And finally, is to develop an induction onboarding program that meets your compliance requirements and builds the right culture. So all of these topics that we've covered should be covered very clearly, trained, understood as part of your induction and onboarding program, and then they should be regularly revisited in other forms. So some questions for you to have a think about. And finally, thank you for listening to our webinar about workplace investigations. My name is Claire Harrison, the Managing Director of Harrison's. These are our contact details. So if you do have any questions, feel free to send us an email. But I thank you for your time today.